Parol Evidence Rule Part 1, the General Rule. The area of the law that this podcast and the 3 following podcasts address is called the Parol Evidence Rule, which is often referred to by the acronym PER. Parol Evidence Rule is something of a misnomer. Parol refers to the spoken word, but the rule applies to any kind of communication, oral or written. And note that there is no final E in parole, unlike parole with an E, which is part of the criminal justice system. Evidence suggests that this is an evidentiary rule, but it's not. It's a substantive rule of law. And rule suggests that there is a single rule, but in fact this area of law encompasses multiple rules. Moreover, each of these multiple rules comes in multiple versions that can vary from jurisdiction to jurisdiction. In sum, this whole area of law is a mess. These modules attempt to impose some order on the area, but you should realize that the opinions in this area are impossible to harmonize into a coherent whole. The basic idea of the PER is deceptively simple. The basic idea is that once the parties have reduced their agreement to a writing, agreed to by both parties, neither party should be allowed to introduce prior or contemporaneous evidence to vary that written agreement. So, for example, if we enter into a written agreement for you to sell your bike plus lock and repair kit to me for $300, I shouldn't be allowed to later assert that you also orally promised to include your helmet in the deal. This basic idea is spread across 4 different restatement sections. 213, which claims to be the parole evidence rule, 214, 215, and 216. In UCC cases, the applicable provision is Section 2-202. Let's break the basic idea down into its component parts. First of all, before the PER applies, there has to be a written contract. If the parties have an oral agreement, there is no PER issue. Second, the rule only applies to evidence that is other than the written contract itself. Such evidence is called extrinsic evidence, that is, evidence from outside of the contract. It refers to evidence about conversations or other writings. Moreover, the extrinsic evidence has to be prior to or contemporaneous with the written contract. The PER does not apply to conversations or writings that occur after the written contract is signed. Such later conversations or writings are considered possible modifications of the written contract, and the PER does not apply to later modifications. So, what is the purpose behind the PER? What function does it serve? The PER is meant to enhance the certainty and predictability of agreements that have been put into a writing. Certainty and predictability are important core values of contract law, because one of the core purposes of contracting is to manage future risk. Assume you promise to deliver widgets next month if I promise to pay upon delivery. From my perspective, this allows me to manage the risk of not having widgets when I need them by getting your legally enforceable promise to deliver them next month. From your perspective, it allows you to manage the risk of not having cash flow by getting my legally enforceable promise to pay you next month. If we put this agreement into writing, the PER will promote certainty and predictability by preventing either of us from later trying to vary the terms of that agreement. So for example, it would prevent me from testifying that you orally agreed I could pay up to 90 days after delivery, and it would prevent you from testifying that we orally agreed the widgets were due in 3 months. In short, the PER is thought to enhance the sanctity of the written agreement. So far so good. Where there's a written contract, the PER bars prior or contemporaneous evidence that purports to vary the terms of the written contract. The problem is that this blanket exclusion is riddled with exceptions, and the devil is in the exceptions. In the next 2 modules, we're going to study 2 situations where extrinsic evidence is allowed despite the existence of a written contract. One situation occurs when there is an ambiguity in the contract. The other situation occurs when the written contract is what is termed a partial integration.